Hey everyone, it's John here on make sure my sound's on that you can hear me. Cloudy, dark, rainy day here in Denver. So I'm at the end of my day here at work, and it's been kind of a crazy one. Um, but wanted to get this in before I left, and I will post it sometime tonight. Anyways, just wanted to welcome you all to week 3 and call out just a couple of things before we go into. I want to talk about a few things, a few notes that I have from this week's reading material. Just a couple of things, just to reiterate a couple of things. Number one, hopefully you've gotten from my feedback thus far that I am, I'm not. This is not a class where it's there's a right answer and there's a wrong answer. There are definitely wrong answers, right? I mean, as we go into HIPAA and things like that, you can definitely be wrong, but you have to have the analysis to support your conclusion. And so I'm not as concerned about this is the right answer, this is the wrong answer. I'm concerned about, first of all, what is your analysis? Are you following that format? So, as we move into this Aitaraldi case, as we do other assignments with this case, you're going to be asked to look at the legal components of the case, all right? And that's not just malpractice. There are other issues related to the hospital. What about the credentialing issues? And there may be some other things that you need to consider. But let's just take malpractice for a second. We've discussed the 4 elements of a malpractice cause of action, and each one of those needs to be analyzed. So you take the issue. First element is a duty. Did the physician owe a duty to the patient in that case? Well, what's the rule? State the rule. What are the facts? State the facts, the relevant material facts. Apply the facts to that rule and come out with a conclusion. So that's the first element. Second element, there was a breach or a deviation in the standard of care. There was a breach of duty, which is the reasonable the standard of care rule. So what's the rule? Again, facts. Apply the facts. Conclusion. If your analysis is reasonable, then your conclusion will be reasonable, and so that'll be the most important thing. So just remember that. The other thing is, one thing that students get caught up quite a bit in this class is the question about whether or not the court in the Aitaraldi case is determining a question of fact or a question of law. Usually the answers are across the spectrum on this one, and that's fine. It's, unless you're mired in these, unless you have the unfortunate luck of being mired in cases like this every day, then it's not intuitive to know what the answer is to that. The court does mention that they're determining a question of law, and I think it's a standard of review section and the points of error section. But I just want to talk a little bit about the function of that court versus another court. So this is an appeals court. The function of that court is really just to determine questions of law. The facts are decided at the trial court level. So the first level, the first court level, when you sue someone, and let's say there's a malpractice case, plaintiff sues a defendant, they go to the trial court. That's when you'll have witnesses on the stand. You'll introduce evidence. You're basically establishing a record, and you're establishing the facts. So there's a determination of facts. Well, the jury will be the decider of facts, and then a record is created. So then the jury will determine a verdict, or if there's no jury, then the court will determine what the verdict is, or what the outcome is. And then the party that loses may want to appeal. So when they appeal to the next level of the next court level, the appellate court, they're appealing specific questions. So if you go to the Aitaraldi case, go to the points of error section. Those are the questions that they believe the trial court got wrong, that they are appealing, and they want the appeals court to reverse. And so those are all questions of law. There are no questions of fact. So think of it this way: a question of fact is whether or not somebody reviewed the inventory checklist, or whether or not somebody was in a certain place at a certain time, or those just facts of the case. A question of law is whether or not the court applied a certain law wrong to the facts, or anything related to the law as opposed to what actually happened. And so that's the function of the appeals court. So that's just other than that question, not really important to the rest of the class. And so but in case you were interested, there you go. So this week, just with respect to the reading material, there are a few things I wanted to talk about. First are physician professional responsibilities. So physicians, like all licensed practitioners, they're governed by some sort of state board of health. I mean, many of you are nurses or nurse practitioners, so you're aware of that. You're also probably licensed in your state, and you have to live and work within a scope of practice, and certain codes of conduct or statutes or regulations that define what unprofessional conduct may be. And discipline can come in a variety of ways. When you do something that's inconsistent with what the regulation defines as unprofessional conduct, there could be a suspension of license, or it could be revocation of license. It could just be public censure, where they punish you by putting your name on their website as someone who was disciplined. And there could be educational requirements, documenting medical records better. It just depends on the facts and circumstances and how aggressive the board is. I've actually had two cases. I've worked two cases where I represented a physician before a state board of medicine. Those are definitely the most interesting stories. But if I had two takeaways from those cases, number one is don't ever falsify or mess with medical records. The medical records should accurately reflect what occurred and the clinical condition of the patient. Second is always be transparent with the patient, and just the lack of communication really causes so many problems. And so a high level of good communication consistent with your employer's policies and procedures are very important. So those are the big things, and we have an assignment later on in the class that sort of addresses that. The other thing I want to talk a little bit about is EMTALA. If you work in an emergency department, you work in a hospital, you're very familiar with EMTALA, which stands for the Emergency Medical Treatment and Active Labor Act. And to me, this is sort of an intersect between ethics and federal law. EMTALA imposes certain obligations on emergency departments to provide medical screening, stabilizing treatment before they ever ask for insurance information or your ability to pay. So essentially, if a facility meets the criteria of an emergency department, then they have to provide that, and you present with some sort of emergency, they have to provide that stabilizing treatment. They have to provide a medical screening and a stabilizing treatment before they ever ask about insurance. And so, it's kind of this whole ethics principle of, as a society, we don't agree that it's ethical to turn away people who have significant medical emergencies because of their inability to pay. We value, I think this is the theory, is that we value life and health more than someone's ability to pay. And so therefore, I think that's the ethical concept or the ethical theory that has translated into that federal law, which is known as EMTALA. So, we talked a little bit before about how sometimes ethics and laws intersect and overlap, and I think this is one example of that. I want to talk a little bit about patient abandonment, about your text. I think it's either chapter 5 or 6. Talk about that, and we talk about just general negligence, medical malpractice, patient abandonment. They all have very similar elements to those causes of action. Patient abandonment is actually a form of malpractice or negligence that occurs when physicians terminate their physician-patient relationship without reasonable notice. And so there are 5 elements generally. Now, this is a state law issue, so the elements could vary from state to state. However, just generally speaking, I haven't looked at every state, but I'm guessing that every state has similar requirements. First element, healthcare treatment was unreasonably discontinued by the physician. Second, this termination of healthcare was contrary to the patient's will or was without the patient's knowledge. Third, the healthcare provider failed to arrange for care by another appropriate skilled healthcare provider. The fourth is the healthcare provider should have reasonably foreseen that harm to the patient would arise from the termination of care. So that's the causation element that we have talked about in the malpractice context or the negligence context. And the fifth is the patient actually suffered harm or loss as a result of the discontinuance of care, which is the damages element. So there has to be actual harm or damages. So, I mean, the variance from state to state could be in generally I think it's 30 days, but notice, but that could vary based on state requirements. I did look up some types of actions that have under existing court cases led to a finding of patient abandonment. One is like a premature discharge of a patient by a physician, failure to provide proper instructions before discharging, refusal of the physician to respond to calls or to further attend the patient, leaving the patient after surgery or failing to follow up on post-surgical care. So anyways, I mean, there obviously have to be a lot of other facts and circumstances surrounding each of those, but those sort of have formed the basis for previous patient abandonment causes of action. So the last thing I want to talk about, and we're going to talk about this more next week. Next week, we're going to talk a little bit more about medical records and just state and federal law with respect to medical records. But, I just want to talk a little bit about privacy, because your discussion question, it's either next week or the week after, is the question on privacy of protected health information. So, generally, many of you, I'm sure if you work in a healthcare facility or in any capacity, you're probably required to take an annual HIPAA training. So I'm sure you're already very familiar with this. But, under HIPAA, which was enacted in 1996, basically prohibits any use or disclosure of protected health information, which is a defined term, unless an exception applies. And so there are generally 3 exceptions. There are some other exceptions that permit a healthcare entity or a covered entity, an entity that's required to comply with HIPAA to disclose or use PHI or protected health information. Now, I want to bring this up only because, and I'll post this in the announcement, but there's a great resource that I think definitely recommend using, not just in this course, but anytime you have a question about HIPAA. And that's actually the government website, the Department of Health and Human Services. And I'll put the link on the announcement, but it's www.hhs.gov/HIPAA. That's HIPAA, 2 A's, 1 P. It's excellent in terms of just, there's a search bar where you can just type in your question and it'll a bunch of FAQs, rules, guidance, regulations will pop up that are super helpful. So I would definitely recommend you exploring that website if you're interested in anything related to HIPAA. And you'll also see different penalties that have been assessed by the OCR, or the Office of Civil Rights, which is the arm of HHS that enforces HIPAA. And you'll see the biggest breach, as far as I know, for a improper HIPAA violation is that $16 million penalty on Anthem, which is a pretty big deal. It made a lot of waves. But so you can incur some significant penalties for improper uses of disclosure of PHI. Remember that there's no private cause of action under HIPAA. So if you feel like your medical records were improperly, or your PHI was improperly used or disclosed, you can't just sue the hospital or the covered entity under HIPAA. Now, a lot of state laws, there are state privacy laws that may or may not apply, that could provide you with some remedies in terms of a breach of your PHI. But that's an important thing to remember about HIPAA. That's all I have for this week. Remember, I'm just going to reiterate every week about the importance of the analysis. Break down your assignment by sections. Give me section headers. Give me the analysis. Be thorough. If you have any questions, I'm definitely available. Please contact me, email, phone, text, whatever. Just let me know what you need. Hope you have a great week. Take care. Bye.